In this video, I will cover Order 45, which talks about the procedure for reference under Section 257 of the Income Tax Act 1961. It says that a reference under Section 257 of the Income Tax Act 1961 shall be forwarded to the Registrar of the Supreme Court. On receipt of such reference, the reference shall be numbered as tax reference case number so and so of year so and so. No court fee shall be payable on such reference. The reference shall be in the form of statement of the case containing numbered paragraphs spelling out all relevant facts and proceedings which have a bearing on the question or questions raised in chronicle order with relevant dates. It shall contain an account of the conflicts in the decision of the high courts which necessitate the reference. So this reference, need of this reference arose when different courts are giving different interpretation of the issue. Now, the Income Tax Appellate Tribunal shall, together with the reference through its president, submit the following documents. First one, copy of the order of the income tax officer, memorandum of appeal to the appellate assistant commissioner, copy of the order of the appellate assistant commissioner, memorandum of appeal to the appellate tribunal, copy of the order of the income tax appellate tribunal under section 254 of the Income Tax Act 1961, copy of the application for reference under section 256 of the Income Tax Act 1961, and such other documents as in the opinion of the Income Tax Appellate Tribunal may be required by the Supreme Court at the hearing of the reference. The Income Tax Appellate Tribunal shall, together with the reference, prepare and transmit through its president at the expenses of the party which moved the application under Section 256 of the Income Tax Act 1961, along with the order of reference, 3 copies of the transcript in English of the documents mentioned above, of which one is duly authenticated. When the Income Tax Appellate Tribunal refers a case to the Supreme Court and transmits the transcript record of the said reference, it shall give notice of the fact to the parties, calling upon them to take such steps in the Supreme Court as may be necessary for bringing the reference to a final hearing and certify to the registrar of the court the date or dates of the service of notice. The party to the reference under section 256 of the Income Tax Act 1961 shall within 30 days of the service of the notice enter appearance in the Supreme Court and take further steps for bringing the reference to the final hearing. Upon receipt from the Income Tax Appellate Tribunal of the English transcript of the record, the registrar of the court shall require the parties who moved the application under section 256 of the Income Tax Act 1961 to deposit the charges for printing the said record within such time as he may prescribe, but not exceeding 30 days, and with all convenience speed arrange for preparation thereof. It further says that the rules contained in Order 19 will apply to such references with regard to preparation of record and authentication thereof. Upon receipt of the reference along with the documents, the registrar shall lay the matter before the Honorable Chief Justice of India, who shall appoint a bench of not less than 3 judges to hear the reference. Unless otherwise ordered by the court, costs shall be taxed by the taxing officer under the provision of the second schedule to these rules as may be applicable. A copy of the order made by the court hearing the reference shall be sent forthwith to the Income Tax Appellate Tribunal under the seal of the court and signature of the registrar. Save